Morning, Chair. Thank you.
By how many minutes are you late?
Well, Mr. Ramukhalo was counting. He counted 3.
3 minutes.
3 minutes, yes.
You were going to be penalized in terms of your argument time, but 3 minutes won't make much difference. A good morning to all of you. Advocate Hali and Advocate Nkabinde. We are going to afford you 10 minutes uninterrupted to start your argument, and thereafter you will be asked questions if necessary. We agree that you'll each be given 1 hour, and 15 minutes reply, and it will take a tea adjournment. Let's keep to time. Advocate Hali.
Thank you, Madam Chair.
It will be helpful if you can give us your roadmap.
Thank you, Madam Chair. Madam Chair, I appear together with my learned junior, Ms. Lafeto, on behalf of the National Prosecuting Authority. We've launched...
You are going to have to speak louder. In fact, that's why I propose that you come and sit closer to us so that you can hear you, but try to raise your voice. Maybe
Thank you, Madam Chair.
Take the mic closer to your mouth.
Thank you, Madam Chair. Madam Chair, as indicated, I appear together with my learned junior, Ms. Lafeto, on behalf of the National Prosecuting Authority. The NPA has launched an application which presently serves before the panel. That's an application that we have colloquially referred to as an application to decouple. Insofar as the roadmap is concerned, I want to identify the process in the following. The process will unfold in the following manner. I want to first identify what we say is the problem and the relief sought and why that relief sought would sort out the problem. Secondly, we'd like to get into the nature of an inquiry of this type and the statutory basis for the inquiry, precisely what it must entail. And then we want to get into the nature of the National Prosecuting Authority's role in proceedings such as the present. We then want to, as
the last one?
The role of the National Prosecuting Authority in matters such as the present, and then the rights or legitimate expectations / interests of the NPA in proceedings such as the present. In doing so, we will address a number of different issues, including the issue of cross-examination. We'll identify some of the facts, but at the same time, we will emphasize that the facts themselves are largely irrelevant to the entitlement to participate in these proceedings. We will also look at the question of the rules and some of the problems that emanate from the rules. And ultimately, we will address one issue which relates to the question of obstruction on the part of the NPA. It's an issue that has been raised in the heads of argument of our learned friends for Advocate Chauke. I will, in as much as it constitutes their argument, I'll in large measure deal with it in reply, but there's one issue that I thought appropriate, if I have sufficient time to deal with right now. Then, where does the problem emanate from, my lady? The problem starts in the first instance from the limitation on time. And the limitation on time starts in the first instance with the provisions of Section 12, sub 6 of the Act. Can I ask the panel to consider the provisions of Section 12.6 and just identify what the problem is with, insofar as that is concerned? Section 12.6a, capital A, says that the period from the time the President suspends the National Director or a Deputy National Director to the time he or she decides whether or not to remove the national director or deputy national director may not exceed 12 months. So in other words, and it's a concern that has plagued this panel from the outset, it's a concern that is imposed upon everyone, including the panel, by virtue of the provisions of Section 12, sub 6, capital A. The decision, these proceedings have to start and end within a time that gives the President sufficient opportunity to reflect upon what has been presented to him by this panel and ultimately to make a decision whether to remove Advocate Chauke from office or whether to allow him to remain in office. The second problem emanates, of course, from the undoubtedly from the first problem, but the time periods that have been stipulated for the panel, for the work of the evidence leaders to commence and the work of the evidence leaders ultimately to conclude. And that is the time periods as we've identified in the affidavit that we filed. The time period that was there stipulated required the parties to commence by the 17th of November. The panel will recall, and it's set out in the affidavit, the panel recall that from the outset, the different parties had indicated, including the National Prosecuting Authority, had indicated that the volume of documentation was simply too great for people who are uninitiated, people who had not been involved in the process, to understand to get their heads around the volume of documentation that was being presented. At the time, we had estimated that there would be in the region of 12,500 pages. As it so happens, even that estimate has proven to be conservative. The pages, when we last estimated, had ballooned to over 15,000 pages, and the number of documents keeps growing. So there's a lot of different issues that have arisen out of what appears on the face, or what might appear on the face of it to be a fairly simple issue relating to what we have broadly called the decision, the Cato Manor, the prosecution of the Cato Manor Serious and Violent Crime Unit, and Major General Johan Boysen on the one hand, and the decision to withdraw the prosecution as against Lieutenant General Richard Mdluli. Now, insofar as those two problems are concerned, they have a knock-on effect, because it means that the evidence leaders had to wrap their heads around a substantial number of documents and an incredible amount of different information relating to a large number of different witnesses. They had to take a decision on which witnesses to call, which witnesses to obtain statements from, and ultimately how to present the evidence. At the same time, the evidence leaders understood the instructions to be that they had to be scrupulously independent, and by that it also meant that they had to apply their minds independently of advice given by the National Prosecuting Authority, and in particular by myself. When I say instructions, I mean advice given on which witnesses to call and so forth. So without the opportunity to actually consult with witnesses in advance and to assess the relevance of the witnesses' evidence and whether those witnesses should in fact be called and what advantage it would play for the discovery of the truth, the evidence leaders are placed in a position where they either have to rely upon what I'm telling them, or alternatively, they have to apply their mind independently, but in doing so, they have no basis to apply their minds independently. Then the next, and I don't identify this as a problem per se, the next issue that arises, of course, is the obligation on this panel to search for the truth. And And then the question of cross-examination and how cross-examination is to be done. And
Beg your
whether
pardon,
cross-examination...
I'm sorry, I'm not asking a question. I just want to know whether you are following that roadmap.
I've completed the roadmap. What I'm doing at the moment is to identify what the problem is. The first item on my roadmap was the identification of the problem. The second item...
You've given us 2 problems. Are you dealing with the third one?
I'm dealing now with the fourth one, in fact, which is the question of cross-examination and and the importance of cross-examination, and in particular the absence of cross-examination.
The fourth problem.
The fourth problem.
What is the third one?
The third one is the difficulty in the pursuit or the search for the information and the truth.
Yes.
If I can then start with consider what relief is sought. I've identified already what the problems are, and the proposition is that the relief sought in the notice of motion is an answer to the very problems that this panel is confronted with in its pursuit of the discovery of the truth. What we ask for, Madam Chair, is in the first instance an opportunity for the NPA to participate in the proceedings as a party who is separate and independent from the evidence leaders. If one considers the rules as they have been articulated, the rules identify the National Prosecuting Authority as a party to the proceedings. So to that extent, we are much appreciative, but the proposition is that we do not wish to be coupled with the evidence leaders. The evidence leaders have a role to play, and their role is independent of that contemplated insofar as the NPA is concerned. I take the panel in the first instance to the definition of parties. That's contained in the rules at clause 1.1.13. It's a definitional clause, and it defines the parties as meaning the National Prosecuting Authority duly represented by the evidence leaders as defined above. And of course, the Director of Public Prosecutions, who is Advocate Chauke.
Counsel, your 10 minutes is over.
Thank you, Madam Chair. So what we're saying is that when it comes to the identification of the National Prosecuting Authority, whilst the National Prosecuting Authority is much appreciative of the fact that it has already been recognized as a party, it stipulates that it cannot be represented by the evidence leaders. The role of the evidence leaders is to represent, as it were, the panel and to lead evidence in such a way that the panel it provides a buffer between the panel and the parties who are involved or engaged in the proceedings. The role of the evidence leaders is to be entirely neutral. That's been stipulated over here, not only in these proceedings repeatedly, but also in other proceedings where one has an inquiry, whether they be commissions of inquiry under the Commissions Act or in any other context. The evidence leaders are responsible for gathering the evidence, presenting it before the panel, and leading that evidence. Now, to a large extent, that is, in fact, the role that has been identified in the rules, but it has gone one step further to stipulate that the evidence leaders are responsible for representing the NPA. Just as a matter of principle, that cannot be accurate because it cannot accurately reflect cannot accurately reflect either the facts, the factual basis, or the legal basis. The evidence leaders can represent none of the parties involved in a dispute. Then if the evidence leaders, and I say this not only of the evidence leaders, but of any party, if a party or if a group of legal representatives are to represent a party, then that party must be entitled to appoint that group of representatives, and must at the same time insist that the instructions that are given to that representative be carried out. Now, that doesn't accurately reflect the relationship that is enjoyed. The NPA doesn't wish to have that relationship, and the NPA doesn't insist that it can be entitled to either appoint or remove or to give instructions of what is to be done. As a matter of ethical obligation, when an instruction is given to an attorney or any other legal representative, that legal representative, if in the case of advocates, is either to follow the instruction or to refuse to follow the instruction, because at the end of the day, the advocate is the master of the ship. The client, or in this case, the NPA, is ultimately the client that presents whose rights and interests are being represented. The council is not duty-bound. Any council is not duty-bound to follow those instructions, because he or she is the master of that ship. He's been selected by the NPA, and he or she operates under certain ethical obligations. But if the client refuses to follow those, if the advice having been given to the client is rejected, then the client insists that a particular line of evidence or questioning should be presented, then the council has to withdraw. That right is not available to the NPA in this case. So as a matter of fact and as a matter of law, the description of the evidence leaders as being the representatives of the NPA is simply incorrect. So irrespective of what other relief may be granted, and irrespective of whether the NPA has a right to participate, and we'll debate that in a moment, the fact is that the rules cannot stipulate that the NPA is represented by the evidence leaders.
Let's take it from there. The fact that the rules define NPA as a party, does it necessarily mean party in the sense of us understanding what a party is in litigation? A very brief answer, because I want to follow up with some questions.
It's difficult for me to answer that question because I don't know what was intended with the question, but the brief answer is I accept that it was intended to mean that the NPA was supposed to, was related to these proceedings in the sense that it was the complainant through the National Director of Public Prosecutions.
In the sense that the NPA initiated the establishment of this inquiry, maybe as a complainant, if I may put it that way?
Indeed, Madam Chair. Can I just take that just one step further to say this? The NPA, like any other person, may lodge a complaint with the President, and the President may then establish the inquiry. The initiator of the inquiry is always the President. It may be information that emanates from a specific person. It may be evidence or information that emanates from a body of people. In other words, there may be more than one complaint. But whatever the case may be, the initiator of the inquiry, as a matter of law, is always the President.
Yes. Do you accept, and I think you have accepted in your papers, that the NPA does not prescribe a procedure in terms of which the NPA is entitled to lead evidence?
So there's two questions. The one is about what is prescribed, and the second is about the procedure.
Yes, I don't want to take your time because you only have a very limited time.
Indeed.
So
Thank you, Madam Chair.
we have read your papers, by the way, Councillor.
Thank you, Madam Chair. I'm going to...
I would like to just clarify a few things because you may end up not arguing your case fully if you take so long to answer these questions. The point is this, and I'm sure you'll agree with me. The President exercised his powers to establish an inquiry in terms of the NPA Act.
Into the panel, with respect, that is correct. With regard to the second, I don't know what the answer
Well,
is.
the President has appointed the evidence leading team. It is there in the proclamation. He exercised his discretion to appoint the evidence leaders. And the NPA has been afforded an opportunity to be represented. And in fact, it was at the instance of this panel, myself in particular, during discussion with the ministry that the NPA should be represented.
That was my understanding of the facts as well,
It
Madam
is
Chair.
in that light, if you may allow me to finish, it is in that light that right from the outset, we have appreciated that the team that leads evidence is the evidence leading team. With your support as NPA, as the repository of all information pertaining to this inquiry. We've discussed that several times. That is borne by the transcript. And we have come to an understanding that, and please correct me if I'm wrong, that the NPA is here to work hand in hand with the evidence leading team, to assist the evidence leading team, to give them the information because they don't have information. The only information can only come from the NPA. And you make it so clear that you have volumes and volumes of document as the NPA. You mentioned that from the outset. All the more reasons why the NPA should cooperate with the evidence leaders. We discussed that, and you agreed that you will, as NPA, you will work hand in hand with the evidence leaders. You will provide them with information and work as a team. Is my recollection correct?
With respect, Madam Chair, there was a request that we should work together with the evidence leaders, and we've acceded to that request. We maintain, irrespective of what the outcome of these proceedings today might be, we maintain that we will continue to do so. Principally because to describe us as being the repository of all the information, I think is to be, might overstate the case. We certainly are the repository of a lot of the information. Some of the information relates to people who are not within the NPA. So therefore, and people who never were within the NPA. I'm talking now about certain witnesses and so forth who are external to the institution. So to that extent, we certainly have most of the information, or either have or have had most of the information, and we remain committed to providing whatever information and documentation within the parameters of human possibility and within the parameters of understanding that some documents...
Let us not take so much a long time, Advocate Halley, because you are taking your time. When we had discussions in chambers, even in the correspondence you directed to this panel, right at the outset, you mentioned that you are in possession of volumes and volumes of documents which will be overwhelming to the evidence leading team. Correct?
Correct, Madam Chair.
It is on that basis that I'm making the statement.
I accept that, but
If I may finish?
Sorry, Madam.
And it is in that context that we verily believed that the NPA is here to support this inquiry through the evidence leading team. Because as they lead evidence, they can only do so through your support. And you have conceded to that if you look at the transcript.
We're not. Sorry, could I speak?
The support. That you will support the evidence leading team. And the issue that arises now, as I understand your papers, and correct me if I'm wrong, is essentially that the evidence leaders are not presenting or representing the NPA or presenting the evidence as you would have liked them to do so. Am I getting it correctly?
So what we've said is that there's an incredible amount of information that is out there. And it's not a question of whether we would like them to have presented the evidence. They've got to make a choice on how they present the evidence. It's not up to us to decide that. But we say that it is up to us to present evidence or information that goes beyond what they may decide to present. They've got to exercise their discretion independently and not be directed by us as the NPA. So to that extent, what we're saying is there's an incredible volume of information. Insofar as the panel is desirous of obtaining or of ascertaining what the true facts are, we have information, and it's not, I'm not saying that it's a matter, the problem may be twofold, theoretically. The problem may be a fact of the volume of information that they need to process and assimilate in order to present properly. It could be that problem. We think that that plays a major role over here. The second problem may be one of having considered what all the information is. In the exercise of a discretion, they've decided not to present certain information. So we're saying that in either one of those instances, if the truth is to be ascertained, the NPA has to play a role in these proceedings.
Has any information been presented to the evidence leaders by the NPA to be brought to the panel's attention and the evidence leaders declined to do so?
I think to use the word declined would be, so to answer the first question, the answer is yes. A lot of that information.
The answer is yes, that
yes.
Information was presented to the evidence leaders.
Information has been given to the evidence leaders. I will refer to certain documents at a later stage. So the bundles are there, the information is there. It was a question of how that information has to be presented. We don't ask the
Before
evidence
you proceed, let me just finish my question. Has that evidence or that information that you say has been presented to the evidence leaders been brought to our attention in this application?
We've raised the point about Advocate Norco, and we've relied principally at the time when the application was initially launched. It related, because at that stage, only 2 witnesses had testified. I don't want to talk about Advocate Shabila Batoy. In relation to the second aspect, it relates to Advocate Norco.
But the information that you are talking about, we have seen the point that you are making in relation to Advocate Norco. The information you say you presented to the evidence leaders, what information is it? Is it part of this bundle, this application?
It's part of the bundles.
Is it included?
It's in the bundles.
No. I'm talking about the application itself.
So, no, it's not in the application itself.
So
we haven't itemized what that evidence is,
yes,
other than to make the point that it relates to Advocate Norco. It relates to the failure or the fact that Advocate Norco wasn't questioned about her understanding of POCA, the Prevention of Organized Crime Act. We say that her understanding of POCA is incorrect. Secondly, that there were, in her testimony, Advocate Norcal spoke at length about the fact that she had not been afforded a proper hearing, and she then referred to a report or a memorandum that had been distributed as some kind of communique within the NPA.
Now, I'm sorry to...
Not at all, Madam.
You get long-winded, Counsel, and you still have so many points that you would like to present to us. But we have to ask you a question. I thought that you'll be shorter. Take it to the chase, because we have read your papers.
Thank you, Madam.
We just want to clarify a few things. The issue relating to Advocate Noko, is that the only issue that you brought to the attention of the evidence leaders?
From the outset,
is there any other issue or other information that was brought to their attention?
Madam Chair, there's all the information relating to the entire case. We've got a bundle of documents, and we have on several occasions, and of course the constitution of the evidence leaders has changed or altered over time. Different people have entered, and some have left, and others have arrived. So, but we've speaking about the evidence leaders, however constituted. Yes, we have communicated the information to them.
Now, when you make an application such as this one, given the backdrop that we all understand that you work as a team in the sense that the NPA is here to support the evidence leaders with information, because they can only get the information from the evidence lead, from the NPA, and that you have communicated to them certain information that you wanted them to bring to the attention of the panel, and seemingly they didn't do so. Is that the understanding?
So, Madam Chair, let me just deal with the question of bringing the evidence to their attention and to separate that from putting the evidence before the panel. We present them with what the case is. We're not saying to them, you must bring this to the attention of the panel, and that we've never dictated, because that we understand is within their discretion.
Yes, but when such an approach resulted in the NPA being dissatisfied with the manner of their approach to the case, to this inquiry, which has seemingly resulted in you applying to be given the opportunity, was it not important for the NPA at any given time to rise, or even to tell us in chambers as we meet every morning, that there is information, and give us the details of that information, because we don't have that information here, and tell us what is it that makes the NPA unhappy with the procedures or proceedings as it developed? We have never been told.
Madam Chair, so there's two different issues. Let me start off with the first one. Why we didn't understand that it's our position to rise over here, that we were entitled to rise and to raise issues in relation to any particular witness. And that's why we've referred to certain passages within the thing where when we've wanted to raise, whether it be an objection or whether it be the supply of different information, we were reminded on several occasions that we have to do so through the evidence leaders. Insofar as doing so in chambers, we didn't understand that what is to take place within chambers was an opportunity for us to be arguing about additional evidence being led and any question of dissatisfaction with the evidence leaders. And I must emphasize the issue about the question of dissatisfaction with the evidence leaders. We have never raised a complaint about the evidence leaders per se, and we are not raising that complaint now. What we are stipulating is that it's the volume of information and the volume of evidence that we believe is the underlying factor which inhibits the evidence leaders in terms of the presentation of the evidence. So insofar as there's been suggestions of insults being leveled against the evidence leaders, we are not suggesting that. That's not our case. Our case is simply that they've been overwhelmed by the volume of information, and that our role as the National Prosecuting Authority with people who are involved and have been involved in the matter over a lengthy period of time, that we are well placed to present that information. But picking up from the questions that you've asked me, Madam Chair, about whether we should raise these issues in whatever forum, what we're doing now is to ask for that opportunity to do so. Let us now present it going.
What are you saying, Council? The chance of raising these issues in another forum? Please repeat your statement.
Sorry, the forum I speak of is the discussion in chambers. You've raised it and you've asked me about that. What I'm saying is, before this forum, the criticism that has been leveled against our intervention and our application is that we should not be permitted to participate in the manner that we have suggested, principally because we haven't raised these objections before. What we are saying is, based on the objections that we have raised now, we want to participate going forward. It would be quite a different thing with respect if we were confronted, and I'm just using this as an illustration. When an accused person in later proceedings complains that the accused person didn't have the opportunity to present their case at a later stage, then the obvious question that would arise is, was this information provided to your representative at the time? Were you adequately represented, and so forth? It may be a complaint that can be raised at a later stage. In other words, if we find ourselves before a court of law or before any other tribunal, it cannot be an argument that gets raised at this stage when we're actually asking now to be allowed to participate. It may raise questions about what's happened, whether we can go and revisit what has happened in the past, and to that extent it may well be suggested that our failure or our acquiescence is a complete answer to that. But we're asking to participate going forward. We cannot then be criticized that we didn't raise the objection.
Nobody's criticizing you. We're asking you questions.
And I'm not saying
to understand your case.
Thank you, Madam Chair. I'm not saying that that the panel has criticized. I'm saying that the Advocate Chowki has raised that as a criticism.
Let me wrap up on my few questions on this point. There are just many questions, but I think time is not on our side. And I just want to understand really the essence of your application. Given the background of this matter, statutory background, the Constitution, the fact that this is an inquisitorial process, how this panel has worked with everybody from the beginning, engaging with all of you, not only in the hearing chamber, but also in chambers, to facilitate how we work and should work, given the very limited time frame that you mentioned at the outset, that this panel has a very limited time to conclude the inquiry. We have tried to facilitate this whole process by making sure that we work together to unravel the truth. The NPA has taken a stance that it wishes to present its case because it is a party. It is not clear to me, however, why the NPA has not been able to present the information it seeks to present to the panel through the evidence leaders.
So we've raised several factors. One is we've identified what we consider to be the problem. In other words, the volume of documentation. We've identified that the NPA's representatives, myself in particular, has a much longer lineage when it comes to this matter. I've been involved in this matter for now, probably nigh on 2000, or different aspects of the matter for almost 6 years.
Yes, that should have made it even more easier. That should have made it more easier, Advocate Halley, for you to assist the evidence leaders. Because of your experience, your involvement with the NPA, not only here, but also before the Zondo Commission. So your being here should really be a supportive role, more than anything else, because of your experience, your involvement in these matters before, the fact that you have written an opinion for the NPA in this matter. Why is it that it has been so difficult for you to present all that to the evidence leading team? That's what I want to understand.
As I've indicated, with respect, Madam Chair, as I've indicated, it's simply the volume of documentation. To be able to, and within that volume of documentation, to be able to take the evidence leaders, because there are nuances and there are complexities to each of those different aspects to the case. Those are not things that can be, if it's taken me as long as it did to be able to wrap my head around it, the evidence leaders who have got none of that information, none of the background, would, in as much as it's been supplied to them, would be in an even more difficult position to be able to understand it, because they simply don't have the background. We can provide them with as much background as possible, but it's a matter of not only of being given the information, it's a matter also of having to assimilate the information and having to understand the information against the background.
How do you know that they will not be able to assimilate the information?
Well, with respect, Madam Chair, the information, what I'm saying is based upon common human experience. If it's taken me as long as it has taken me to understand the information, I'm speaking about my own experience. I'm speaking about the experience of those who assisted me at the State Capture Commission and in the disciplinary inquiry that we were involved in. So it's taken everyone who has been involved in this matter an incredibly long period of time to understand it. Yes. So that's the point that I'm making.
Yes. That being the case, you having been involved in this matter many, many months ago, even at the time when the president was approached with this request by the NPA, you were in a better position to tell the president that the evidence leaders were going to be involved in this matter, or even after their appointment, to say they will not be able to cope with the work.
So insofar as after they were appointed, I think with respect we did say that, and we said that before this panel. We indicated on day one.
I'm asking you, why was that not brought before the president? Who appointed these evidence leaders?
Well, my understanding is that the president has to choose a process that he follows. That process historically has been, when one looks at the Mahoro Commission of Inquiry, has historically been to make use of a panel and for the panel to determine how the matter is to proceed, whether it be with evidence leaders or otherwise. We could not have known in advance. We might have had a fairly good idea based upon what the historical experience was, but we couldn't have known in advance.
Do you accept that problem 1 and 2 that you have raised before us are matters beyond our saying? These are statutory provisions that we can't do anything about.
We all subject to that limitation,
Yes.
including the panel. We identify it as a problem, how one has to deal with how one is to eat so large an elephant is ultimately for the panel to decide, and the panel does so through the rules. But it is a substantial elephant that needs to be eaten.
We're going to deal with the statutory structure,
Thank
the
you.
role of the NPA, the rise and legitimate expectation of the NPA.
Thank you, Madam Chair.
Because your time is almost over, I just want to just check very briefly with you. What rights?
So we submit with respect that those rights emanate in the first instance from the very nature of the NPA as a matter of general principle. Sometimes there would be a complaint that might come from within the NPA as this complaint has arisen. Sometimes it might arise from outside of the NPA. Whatever the case may be, as a matter of principle, the NPA, given its location within the administration of justice, given its closeness, its proximity to the person who is to be the subject of the investigation, whether it be an NDPP, a deputy, or a DPP, as in this case, its proximity, those are people who are integrally intertwined with the NPA. The NPA has a right to participate in the proceedings where one of its people is being accused. The NPA is, in terms of the constitutional structure, is the most important repository of the criminal administration of justice. It is
Here, I'm sorry to interpose, here we have a DPP who is the subject matter of this inquiry. There is no relief sought against the NPA. Finally, whatever recommendation this panel makes, that recommendation will be either for or against Advocate Chauke. Correct?
ultimately the mandate that has been given by the President to the, in terms of Section 12 sub 6 read with Section 14 sub 3 of the NPA Act, the President is entitled to conduct an inquiry. The President has been given an incredible leeway as to how he conducts the
I
inquiry.
understand that. I think just get to the point. The question is, the subject matter of this inquiry is Advocate Chauke. Whatever recommendation given the mandate of this panel, whatever recommendation the panel makes will be either for or against Advocate Chauke.
Correct.
And not the NPA. That is the narrow point that I'm raising with you.
Correct. And with respect, I agree with that. That is the mandate that has been given, and that is the only mandate that the President can give to the panel. But what I do want to say in relation to that is that various accusations have been raised against the NPA generally and against...
By whom?
In the cross-examination of different witnesses, principally in the cross-examination of Advocate Batoy, but also in the evidence that was led by Advocate Bayema and even Advocate Norco. The propositions that were being put to Advocate, to various witnesses, including Advocate Norco including including Colonel Mangena, was that there appeared to be a suppression of information or suppression of evidence by the NPA generally, and in some instances it was directed.
Of course, that's the matter that can be argued at the later stage. It's the matter that can be argued at the later stage that there is no basis for those propositions, that information has been suppressed, or you can even argue later that there is no basis to make any findings on those on those propositions. But why is the NPA now saying that it has a legitimate expectation? What legitimate expectation?
So the NPA has a legitimate expectation, indeed a right, to preserve its image, a right the public has an interest in knowing that when there are prosecutions which take place, that there is the public has an interest in knowing that those who participate in the criminal justice system are people who are untainted by any slur upon their integrity, and particularly insofar as that slur might relate to how they have conducted the criminal prosecutions. That applies principally in a case such as the Section 12.6 read with Section 14.3, to where an accusation has been leveled against a person who is at the coalface of deciding whether to prosecute or whether not to prosecute. So even if the allegation comes from outside and the NPA doesn't support the allegation may be against a person, and the NPA believes that it's conducted its own internal inquiries and it is satisfied that there was no wrongdoing on the part of its member, the NPA would be entitled to participate by virtue of its proximity to the criminal justice system and the protection of the image of its own DPPs. In this case, it's the opposite. The NPA is saying that there is something wrong in this case.
I know your time is almost coming to an end. Is there anything in terms of working out? We have looked at my sisters are going to ask you questions, but I just want to alert you, Advocate Hali, that the issues that you identified, the only one that seems to have maybe you want to very briefly deal with is the issues of cross-examination. Whether you are entitled to cross-examine Advocate Chalke. And please deal with it very briefly. You have a few minutes.
So what we say is, if one considers the rules place the obligation to present evidence, to lead evidence. It says that in explicit terms, in the hands of the evidence leaders. Thus far, and it says that in explicit terms, Madam Chair. Thus far, the evidence leaders have not been the ones who have been called upon to lead all the evidence. Instead, Advocate Chalke has been allowed to lead his own evidence and to cross-examine different witnesses. If the obligation, and it is the obligation of this inquiry, through an inquisitorial process, to determine where the truth lies, we've been told in the authorities that we've cited by Wigmore that the right of cross-examination or cross-examination is the single most effective legal engine for the ascertainment of the truth. So if the NPA has a right to participate in presenting the truth, we would submit that an extension of that right is the right to cross-examine.
Good morning, Advocate Hali. My sister has already asked the bulk of the questions that I had. So I'm going to preface with a statement and give you 1, 2, 3, 4 questions that you can just answer in summary. it is common cause that you have been involved in this matter for quite some time. And you even, I think in your opinion, you even indicated that you settled, or you were requested to settle the letter that goes to the president.
That is correct.
Requesting the initiation of this inquiry. Now, based on that, and based on your knowledge of everything that is happening, especially the documents, you keep on referring to the volume of documents, which is something that you said right from the first day. And given that the evidence leaders were relying on you, and I will use a word that was used when we first started, that you as the repository of that information, you would act as a conveyor or as a conveyancer to the evidence leading team by giving them firstly, the relevant evidence, secondly, the relevant witnesses that needs to be called, given your knowledge of this whole issue. And my question would be, have you done that? Then the second question is, it has been 5 months since we started, and you are bringing this application now. Tied to that is what you identified as the problems, the limitation put by Section 12B. I think it's A, that from suspension to the decision by the president, it should be within 12 months. Now, by bringing this application now, after we've been running for 12 months, or after we've been preparing and sitting and doing our work for 5 months, what is the end game? Do you see us finalizing this matter and being able to write the report and sending it to the president within 5 months, within the remaining period? If we are going to have the evidence leading team doing what they do, and then maybe asking clarity-seeking questions and having cross-examination with every witness that might come, which we know will prolong the time. And back to the documentation, you keep on saying maybe the evidence leading team would not be able to assimilate the issues and the nuances in the documents. And one wonders, all of us sitting in this room, including, well, I'm not sure to what extent Advocate Chauke's team has had to work to understand and assimilate, but I'm asking myself, doesn't the same apply to this panel? Because we have to go through the same volume of documents, and worse for the panel, understand it to a point of making a determination and writing recommendations to the president. And then lastly, was the president, when the request made, was he made aware that the evidence and the documentation that is needed that to run this inquiry is in excess of 12,000 pages, such that when he determines the time frames, he is aware of that, or even before determining the time frames, was he given a chance to see what type of evidence does the NPA have in order to request this type of inquiry? Thank you. I think I've asked maybe 6 questions, but Chair, thank you.
To answer the last question first.
And Council, if you can try to be brief
Indeed,
in your
Madam
answers,
Chair.
you have 5 minutes.
Thank you, Madam Chair. To answer the last question first, I'm not aware of what was given precisely except to the President, except what has since been presented to me. So I would communicate information to the NPA insofar as information was requested. Subsequently, I've now been presented with documents, and I've been told what was given to the President. I don't know what outside of that was given to the President, but on the information that I've been given thus far, which has also been placed before this panel, it would appear that the President was simply advised of the fact that it related to two matters, and he would have been given the reports that were attached. That was the Broughton report and the various opinions that were attached to it. It might not have been sufficient to foreshadow the true magnitude and extent and complexities, and in addition to that, the volume of documentation. I'm not sure if that answers the
part
question.
of the volume of the document include the dockets.
Includes
Because
the dockets.
what was given to the President does not include the volumes of dockets and
Indeed.
indictments.
My understanding is, and I really cannot comment on this beyond what I'm about to say, my understanding is that the correspondence with the President typically has to be succinct and as far as possible to exclude the volumes and volumes of information. And one can understand that because decisions have to be based upon what is being conveyed. So one has to capture the essence of what the complaint is. I trust that that answers your question, Advocate Baloy Mary.
The issue of 5 months, the application now? Why now?
So there's two aspects related to the application now. It will be recalled, and it's raised in the papers, that the indication was given as far back as early December that there would be an application of this type. That, in other words, before Advocate Batoy started to testify, unfortunately, by the time the application had been completed, in other words, the papers had been drafted, the Advocate Batoy was already under cross-examination. Questions had already been posed to her, and the concern that had been raised by the EXCO was that if we were to present the case at that stage, it may be perceived as an opportunity to try and, in light of the fact that these proceedings are published and that the Advocate Batoy would have easy access to it, if we were to present the case, it would be heard in open hearing as it is now, and that she would know what we are saying and why what we are saying might be perceived as an opportunity to influence her testimony.
What about the effect on the time frames?
So, unfortunately, the effect on the timeframes is an inevitable consequence, but it applies to everyone in like measure. What we're saying is that if all the evidence was to be led, and the panel's principal concern must be trying to ascertain whether Advocate Chauke is fit to hold office having regard to all the evidence. If only one party is presenting that evidence and only one party is interrogating or cross-examining allegations against himself, it would mean that the panel would, by the time it's completed its task, and it may well be so that the panel has to say, as a matter of practicality, that the guillotine has got to drop now. What we have is what we have, and we must proceed forward. But if the guillotine is to drop on the NPA without all the evidence being presented, it would mean that Advocate Chauke, as has happened over here, Advocate Chauke spends 3 or 4 days leading witnesses, and there's an hour's questioning of those witnesses. With respect, that cannot be in the interests of justice. Whatever may be said about the case which the NPA presents and whether the panel is ultimately in agreement with that case is a matter for a different day. But for present purposes, we ask only that we be allowed to present that case so that the panel is also au fait with what we're saying is the actual case of the NPA.
With a lot of information that you have at your disposal, given this limited time, what period are you looking at? How many days are you looking at? Even if you are inclined to afford you the opportunity, because you have not told us that, and
Well,
you know we have only 4 months to go.
So what we're doing is the relief that we seek is simply to augment the role played by the evidence leaders. We're not asking to lead, to present a case that they don't intend presenting. We simply want to present
No, we
something.
understand that. You have referred us to the witnesses that you have mentioned that there are witnesses that you may want to call from the founding papers. We don't know how many witnesses. We don't know how long that will take, and that's why I'm asking you this question. If we are minded to afford you the relief you seek,
So we would have to sit down with the evidence leaders about, we've seen what their list was. We've suggested additional people to be added to the list, but we can't imagine that it would add, and bear in mind that our estimate in the past has proven to be inaccurate. We assumed that Advocate Betoy would be in the witness box for only 2 days.
Actually, you're not answering my question.
I'm trying to be as...
Yeah, try to be short. You have asked to be given an opportunity, and I'm saying to you, in the event we are inclined to grant you the relief you seek, because you have not told us that in your papers, we know that there are possibly some witnesses that you want to call. Now the question is, how long a time will you require?
Insofar as witnesses are concerned, I can suggest that there would be in the region of about four or so more days as far as witnesses are concerned. Insofar as
How
cross-examination...
many witnesses have you identified that you have not even told us about in your papers?
Well, I haven't, to be fair, I haven't actually tallied them up before I
The
came.
question is, how many are they?
We anticipate that we're talking about in the region of about 3 or 4 witnesses, Madam Chair.
Yes, thank you.
Advocate Hali, are there any witnesses that you have proposed that the evidence leaders present evidence through, and whom the evidence leaders have refused to call?
Madam Ramaphosa, as I indicated before, in the discussions that we've had with the evidence leaders, they've never refused to do anything. We present them with it. We don't know whether they take it into account or don't take it into account. But to answer, so because they're not taking instructions from us in that sense. But there are additional witnesses that we would like to call additional to what is presently on the list.